4. This case system, precedent. There are psychologists who delight in talking of an apperceptive mass. I am not quite sure what such an apperceptive mass may be, nor of whether it is at all. But I am very sure that these psychologists have a strong truth by the tail. The only question, as A. G. Keller used to put it, is whether, for all our firm grip on the tail, we shall have skill and patience to work up over the rump. The truth that we have seized upon is this. You see in your case almost exactly what you brought to it, and hardly more. If you bring much, you see much. If you bring nothing, that is what you see. A little, each case will add to what you knew. The measure of what it adds again is what you bring. This point I dwelt on lovingly in the last lecture, in regard to briefing. I shall dwell on it now again, in reference to review. Case study progresses slowly. It works intensively. It works, because it must work intensively, upon a tiny body of material day by day. Hence you can seem to do the work, and seem to follow, although each day you have in mind the cases for the day, and nothing more. At this point, gentlemen, we meet the rump. You seem to do the work. But if you are to do it, you require, each day, each week, to build your new material together with your old. You require to enlarge, above all you require to consolidate. You're a perceptive mass in law. You require to bring to each new case, and each new briefing the whole of the body of the knowledge you have that far met. The crux of your briefing. What does this case add? Develops value to you in exact proportion to the size and quality of the existing stock of skill to which the new addition will be made. Now I know well that you have heard all this before. I know that you have met before our old familiar frog. 3 feet a day he climbs out of the slickery pit. 2 feet each night he slides down as he sleeps. The benighted frog does not dig in between whiles. He takes no thought about his apperceptive mass. He does not, in the military jargon, consolidate his position. Having no tail, he does not see the problem of surmounting rumps. Yet you perhaps lay claim to being more than frogs. Presumably, at least in theory, you own intelligence. The dean's office vouches that you have got by our private lunacy commission. You should thus understand me when I tell you that the only road to making the slow-moving case instruction gain momentum is to accelerate the learning process day by day. The quantity of new material studied you will not much increase. The quantity and quality of what you get out of your new material can jack up daily. But in one way only. By daily, by weekly, going over, arranging, consolidating what you have. Our class instruction is invaluable to you. But I insisted yesterday, valuable only as you labor through the problems first yourself, as you prepare yourself to see what goes on in the class. And I insist today, valuable only as you work through the problems afterward yourself, or in a group, build what you have seen into a working part of your equipment for tomorrow. Our class instruction, as a catalyzer, is all that you have hoped. But by itself, it is a poorer show than Keith's theaters, at higher prices. Now I have told you. Before this lecture closes, I shall hope to indicate enough niceties in the material, enough lines fine, yet profitable to follow, to stir in you some realization of the meaning of the telling. Just this last thing to end the exhortation. Your instructors, many of them, have taught some cases 10 or 20 times, and studied those cases over each time before they taught them. Constantly, they are finding new things, new light, new problems in that same material. They have meanwhile increased their apperceptive mass. They sit triumphantly astride the beast. One other point I wish to make in the same connection. Note-taking is well nigh essential. Writing helps memory. Writing records. What seems so easy to remember slips away. You need it, if you would consolidate. But note-taking, like briefing, is a treacherous tool. Notes that have any value are not copied down. Before the writing down goes a critique. Notes that have value are not what is said. They are a selection, a working over, a working up, of what is said, a preservation of the queries opened by the instructor, a preservation of the independent queries which occur to you. If you are actively though silently engaged in the discussion, your mind must open queries as the class proceeds. Those things belong in your notes. What the instructor gives as information then has some reference value. You can see its setting. You can judge whether it is holding or mere dictum. It is much harder. It is much slower to take notes this way. It is much harder. Reacting, rephrasing, you must think to take a note. Selecting in the light of the discussion, the essential from the surrounding whirl of words, you have to give attention, to be using the stuff between your ears throughout the whole discussion. So too, it is much harder, much slower, to brief cases with intelligence. It is much harder, slower, to put in daily time upon consolidation of your notes. These things take guts, some mental and some moral. They are the conjugations and declensions and syntax of your study of the law. They are your plant, your engine, your machine. If they are grubbed through once, and grubbed through hard, if they are once put together and set moving, then you have them. The outlay on investment is complete. Within a month or two, they pay out dividends. Within 6 months, you find them a bonanza. Then your machine is oiled and running smoothly, while your neighbor who speeded blithely through the football season knocks and stalls. This is a wisdom hidden from the frog. So, I have said my piece. Let us get on to something interesting. We looked yesterday at the art of matching cases to extract the rules from them. Today we go further. We take up what can be done with such an extract when you have it. We take up also some of the less systematized lore which lies in the cases if you have the wit to find it. The two types of study interlock. Both take us back to the cases themselves as the ore which we are to refine. For the cases go some distance to show us what types of dispute arise. Here, as in the measuring of effects of rules, we must indeed recall that the facts assumed or adopted by an appellate court have gone through straining and distortion. We shall not attribute to them, therefore, any quality of accurate description of the events they purport to bring before us. Yet, as historians have learned, much can be pieced together from accounts which may be biased, partial, even propagandist. And in my constant reference, for convenience, to the facts of cases, I trust that you will understand me as always assuming that the cases in this aspect of their facts are to be read, and will be read by you as an historian would read a document looking for evidence of bias, of omission, of distortion, and concluding to the facts not as one would conclude from laboratory evidence, but as one would conclude, say, from the London letter of a fairly skillful correspondent. The cases, I say, give us an indication of what types of dispute arise. Being cases at law, however, they indicate in the first instance not disputes in life, but quarrels before the courts. Now I have already argued that quarrels before the courts are but a minor fraction of the quarrels of life. I can go further and argue that quarrels in life are a still lesser fraction of life's business. Both points need stressing as we seek to place the meaning of the cases. Are the facts typical? And typical of what? You will find one great group of litigated cases which were predestined to be litigated. They bear the same relation as does homicidal mania or sleeping sickness to our normal life. They are in court because they are so exceptional that the normal ways of society have afforded no solid basis for deciding them, or even because the ordinary machinery of adjusting cases in society has no teeth which fasten on them. The rules which arise out of such cases may be very useful. They may indeed to lawyers become of vast importance. The lawyer specializes in this flotsam of events, as the doctor specializes in diseases of the eye and ear. What to him is the mine run of his cases is to the ordinary man accident, misfortune, the event of a lifetime. Indeed, such cases may be thus exceptional to the layman over whole groups or over whole communities. I strongly suspect that a great bulk of our rules will prove on study to touch only these pathological cases. Such rules have little touch with rules for living life. By hypothesis, any cases which call them into play are in the living of life extraordinary, unforeseen. They enter into calculation at most as remote contingencies against which, however, it may pay to seek protection or insurance. Such rules, then, are rules for decision, rules for officials, rules for the most specialized of specialists. They interest you because you may become such specialists. They interest you also because to you, they suggest contingencies which no ordinary man would think about. but which, when he comes to you for counsel, may well often give you the wherewithal to furnish him more adequate insurance service. But much more important, much more vital, much more focal for your study and your understanding, are those cases in which the rules hit closer to the norms of living. Those disputes which typify whole groups of interest clashes commonly occurring. Here the rule laid down will be a rule whose application people may foresee, a rule whose application, even if they do not foresee it, threatens them. Here then is a rule to which men can and should and often do orient the action which they take apart from litigation. Most commonly, you will find cases of this sort upon the growing fringe of institutions. A new type of contract, of market organization, of insurance, of corporate stock has been thought hopeful, has been tried out. As yet its outlines and its bearing are not certain. A dispute arises. The two parties each honestly regard as right the view which will be favorable to him. There can be doubt. The ways, the attitudes of men who deal in the connection are not yet fixed. They fluctuate. They are conflicting. The issue may be compromised, and no case reach the courts until the social processes of trial and error and of imitation have worked out fairly definite results. But quite as likely is that the dispute will come to litigation. Perhaps it is pushed as a test case purposefully. Perhaps it comes by social accident, and merely because one party proves to be stubborn. In either event, a test case it will be. The court will pass upon some feature of a half-formed institution. Such test cases, once they are decided, shape, limit, block its further growth. If, as is likely, the court in the future stands by the decision it has once made, that decision shapes not only the further growth of the law, but the further action of the community. So the decision may have been handed down 2 centuries ago, and still be one which has made and left its mark upon the social organization of today. This is the one side, the power of courts over society. The other has been already intimated, the power of society over the courts. It is society, and not the courts, which gives rise to, which shapes in the first instance the emerging institution, which kicks the courts into action. It is only from observation of society that the courts can pick their notions of what needs the new institution serves, what needs it baffles. Partly courts look directly at society. Partly they look at the deposit of their own work, made in the past on similar occasions, that is, at the existing ways of law. In any event, if the needs press and recur, sooner or later recognition of them will work into the law. Either they will induce the courts to break through and depart from earlier molds, or the bar will find some way to put new wine into old bottles, and to induce in the bottles that elasticity and change of shape, which, in the long run, marks all social institutions. Or finally, if the courts stand fast themselves, and clamp down the lid too, on the bar's experiments, then, if the need resurges long and hard enough, the change will be made by way of legislation. Each case, now, which is not one purely pathological, is an experiment in this great laboratory. And the problem is how to milk that experiment for your training. The first thing, not only for this purpose, but indeed for any, is to visualize the initial transaction between the parties. Who were they? What did they look like? Above all, what did each one want? And why did he want it? If you can see the facts in their chronological order, one by one, if you can see them occurring one by one as particular people, be they well or ill-advised, were moving to the accomplishment of their desires, if you can see these desires, and feel them in the light of who the parties were, and of their situation then, and then only will the case become real to you, will it stick in your head, will the words speak and set your mind to working. Call this, if you will, dramatizing. Call it, if you will, the writing of fiction. It resembles them at least in this, that to do it will require you to loose your imagination, but with discipline. Will require you first to feel yourself into the situation as depicted, and then to see, to feel the texture and the rough knobs of each fact. So equally when the case arises out of an event. You will, I may say, find it very useful to take this distinction between transaction and event, to keep it in mind. We have a transaction when 2 or more parties get together to accomplish something. They bargain, they sell, they lease, they write insurance. Here, before the dispute, there is a deal. Here, the possibility offers, always of shaping the transaction in advance, and with design to the ends of the two parties or of one. Here, therefore, there is room for all kinds of legal safeguard, room for the work of counsel in the office. But what I am calling events will rarely be intended by both parties, if by either. A man is killed. It may be purpose in the killer. It rarely is in the deceased. There is a brawl. True, in a sense, the two parties deal together, and now that the brawl is on, they may be dealing with intent. Still, it is rare to have the brawl in mind beforehand. With events, equally, however, visualization helps. But their dramatic character leads commonly of itself to your doing what visualization you may need. Hence the facts of tort cases commonly are easy. But in the facts of contract cases or of property cases, you are more likely to have to drive yourself to the work. Drive then, for it is needed. There is more, however, to dramatize than merely what the parties wanted or what they did, especially in the transaction. There you have eternally the question, what would you, had you been counsel, have advised this man on this point, at each stage of the negotiation? How do you analyze the facts thus far? What is their legal meaning? How will that legal meaning bear on this party's proper course? If you can read facts thus, the case is no longer flat. It foams as golden as Toronto ale. Fine bubbles rise. Did the court read the facts as did the parties? Did the court see what the parties were driving at? To put the question in legal phrasing, was the court's interpretation of the facts sound? This leads us into one of the most striking and useful discriminations that in your reading of the cases you must make, to wit, the difference between the rule of law laid down on a set of facts assumed on the one hand, and on the other, the way the court interpreted the facts before it. I like to call these the two levels of the decision. In logic, you will observe the interpretation of the facts comes first. There are some statements in the record as to evidence. You give a meaning to these statements. You decide precisely what they mean. Your application of a rule of law bears then on what you have already decided to be the meaning of the facts. It does not touch the raw evidence at all. It touches only the final product that remains after the evidence has been worked over. Yet in life, the operation may be the reverse. Rule and decision may dictate the interpretation of the facts. For it is clear that if a later court, in pondering a case substantially equivalent, does not like the results achieved by the earlier court, then it may reach a contrary decision in either of two ways. Either it may reject the rule laid down by court number one, and this is not so likely, or it may accept that rule as a verbal formula, may cite the prior case as authority, and yet interpret the raw evidence before it differently, saying that due to the difference in the facts, the rule does not apply. For example, it is conceded on all hands that if A makes B an offer, and B then writes a letter which purports to be an acceptance, but which adds a new and different term to the proposed agreement, and which further conditions acceptance upon the introduction of that term, then B has not accepted. This rule looks clear enough. Yet it means almost nothing until you get down to what I have called the first level, and see how the courts in their work interpret different kinds of letter as falling inside or outside the rule. A offers B, for example, a deed of his Greenwich Village stable for $30,000 payable Tuesday. A is in New York, B in Philadelphia. That offer, by itself, means $30,000 payable in New York. B replies, offer accepted, money available, Girard National Bank, here, send on your deed. Is this a new condition, or was it a mere suggestion that a shift the place of payment? Not all the universal agreement in the world as to the rule can give you light on this. From which I reason, until you study the first level of decision, the interpretation of the facts at hand, you do not know the rule. I do not care what you may know about its words, until you know what the words stand for. This is important in putting your cases together. It is important, too, in saving time. For it does not pay to quarrel with the rule of law laid down by a court, because you just do not like its way of interpreting the evidence. You can see and approve the rule of law announced and still reserve your quarrel upon the evidence. But to quarrel intelligently, you must clarify the issues. On the other hand, when it comes to seeing the bearing of the rule on life, on actual disputes, on actual transactions, it is clear that the first level moves into the limelight of your mind. This brings me now to a further point about the courts. Some courts, in their work of interpretation, you will discover very eager to find what the party's situation really was, to read their words, to interpret the bits of evidence as the parties themselves would have regarded them. Such courts feel their way into the situation as you ought to. They take you with them. Other courts sit in what seems to be sublime indifference. They act not only in their laying down of rules of law, but even in their interpretation of the facts, as if life had been made for law. We find, I say, in the interpretation of the evidence divergencies in attitude among the courts. And this concept of attitude carries further. I spoke in the last lecture of a common occurrence, that we turn up two cases which the two courts have put upon two inconsistent grounds, upon two different, two conflicting rules. I spoke of the possibility of framing a third rule which would, as the phrase goes, reconcile the cases, a rule, perhaps, which differs from that laid down in either case, but which would warrant and indeed require both results. Commonly, this is achieved by taking a distinction, by picking out some feature which differentiates the cases, but which neither court has stressed, and by insisting that this differentiating feature is what accounts for the results. The differentiating feature may be a point of fact. It may be a difference in the procedural setup of the cases. In either event, its striking aspect, from our angle, is that the distinction taken occupied no great amount of the attention of the two courts under discussion. Which brings us to the point of attitude. Granted that if a court desires, it will find the distinction sufficient to harmonize the cases granted. That is to say that the distinction makes technically possible our proposed solution. Remains the question, will a court do this? Will any court do this? Will either of the two courts under discussion do it? Or will they say, each one of them or either, when facts do come before them like those in the apparently opposing case? We cannot rule as the court there did, because in our first case we settled the rule to the contrary. Here, you observe, we have passed out of the realm of pure logic. We have indeed passed out of the realm of pure scientific observation and inference. Logic and science can tell us, and tell us with some certainty, what the doctrinal possibilities are. They can tell us whether, without self-contradiction, the results of the cases can be so settled as to stand together. They can even provide us with a tool for argument to a court that the cases should be made in this fashion to stand together. But they give us no certainty as to whether the possibility embodied in the argument will be adopted by a given court. But here is a situation in which the very aspects of the case, which give us most trouble when we seek pure doctrine, come now to our help. The phrasing of the court, the points that it picks out for stress, the patience or impatience displayed in dealing with cases cited, and with contentions of counsel, the interest or lack of interest shown on the level of evidence, interpretation, and what the parties seem really to have had in mind, the bluntness or the delicacy of the logical tools with which the court has reasoned, these lay the foundation for a prediction not sure, but very helpful, as to how the particular court in a later case will respond. Not the least helpful thing in reaching such a prediction is the occasional presence of an extra opinion of some other judge. In the English courts of appeal, it is the common practice for each judge successively to give his opinion on the case. He sometimes makes his own statement of the facts. He regularly puts forward his own reasoning, and finally his conclusion. You will discover that the statements of the facts will often differ, and will differ peculiarly in their emphasis and their arrangement. You will discover further that the lines of legal argument which seem persuasive to the different judges also differ. Occasionally, too, but much less often, there is a divergence in result. Now this challenges attention. If after seeing the same record and hearing the same arguments, different judges emphasize differently, even select differently, the facts which they assume to be the case, it would seem to follow that the manner of selection and presentation of the facts may be a useful indication of the judge's thinking and reactions to the cases. If different judges, moreover, find different lines of argument persuasive in leading to a single result, then it would seem to follow that judges' reactions to the facts are more nearly alike, at least are more predictable, than are their reactions to the forms of words we know as legal rules. Surely it must give pause to any man who believes conclusions can be drawn out ineluctably from the words of general formulae, when he finds these English judges in the same case announcing different rules as the basis of the same decision. One result of the English practice, where the rules and the individual opinions differ, is that it often for a while remains in doubt as to which of the opinions represents for later courts the rule of the case. There are a variety of rations decidendi served up and, so to speak, competing, in the main, whether under pressure of business, since the court can do business faster if but one judge prepares an opinion for each case, or because it seemed wiser to avoid this trouble of leaving the bar often in the air as to what was the rule on which the court preferred to rest the case, or perhaps because our judges in the main are less trained in oral composition than the English, unwilling to prepare an opinion except in writing, and therefore led somewhat naturally to concentrate the labor. For whatever reason, our courts have in the main fallen into the practice of confining themselves to one opinion. That, however, has not wholly rooted out the ancient English practice. Extra opinions we find still. Sometimes concurring opinions, where the concurring judge finds it impossible to approve some portion of the reasoning of the final opinion of the court. Sometimes dissenting opinions, in which the judge feels so strongly the objectionable character of the decision that, not content with voting against it, he brings his views to print with the report. What is of interest here is that when such a dissenting opinion is found, it gives us, so to speak, a second point of observation from which to predict the action of that court in the future. And I may add that while it is very hard to generalize about the effect of a dissenting opinion in the future, certain things seem probable. First, that in the court which decides the case, a dissenting opinion proves that a fight has been had and is settled, and that the majority will almost certainly stay put, at least so long as the same personnel is on the bench. The great exceptions to this rule, and they are rare, are cases in which the dissent, in the words of Cardozo, was the voice of a new day, too unfamiliar to have found as yet the acceptance that awaited it. Outside of the court, which announced the decision, the effect of a dissenting opinion is ambiguous. Always it somewhat weakens the authority of the case, partly because it is by a divided court, partly because side by side with the reasoning of the majority, and weakening its psychological effect, appears another line of reasoning. Yet the argument is often met with, and seems sometimes to have weight, that the very fact of a dissent proves peculiarly careful consideration, and should therefore strengthen rather than weaken the case as an authority. I think we are now ready to lock horns with the problem of precedent and make something out of it. I fear that I am going to have to be as unorthodox in what I say about this as in what I said about law. The one vagary is indeed a corollary of the other. For whereas much or most of what is commonly written about precedent takes as its raw material what judges have said about precedent, I propose to take as mine, not so much what they have said as what they have done about it. First, what is precedent? In the large, disregarding for the moment peculiarities of our law and of legal doctrine in the large, precedent consists in an official doing over again under similar circumstances substantially what has been done by him or his predecessor before. The foundation, then, of precedent is the official analogue of what, in society at large, we know as folkways or as institutions, and of what, in the individual, we know as habit. And the things which make for precedent in this broad sense are the same which make for habit and for institutions. It takes time and effort to solve problems. Once you have solved one, it seems foolish to reopen it. Indeed, you are likely to be quite impatient with the notion of reopening it. Both inertia and convenience speak for building further on what you have already built, for incorporating the decision once made, the solution once worked out, into your operating technique without re-examination of what earlier went into reaching your solution. From this side, you will observe that the urge to precedent will be present in the action of any official, irrespective of whether he wants it or not. irrespective likewise of whether he thinks it is there or not. From this angle, precedent is but a somewhat dignified name for the practice of the officer or of the office. And it should be clear that unless there were such practices, it would be hard to know there was an office or an officer. It is further clear that with the institution of written records, the background range of the practice of officers is likely to be considerably extended. And even more so is the possible outward range, the possibility of outside imitation. Finally, it is clear that if the written records both exist and are somewhat carefully and continuously consulted, the possibility of change creeping into the practices unannounced is greatly lessened. At this place on the law side, the institution of the bar rises into significance. For whereas the courts might make records and keep them, but yet pay small attention to them, or might pay desultory attention, or might even deliberately neglect an inconvenient record, if they should later change their minds about that type of case, the lawyer searches the records for convenient cases to support his point, presses upon the court what it has already done before, capitalizes the human drive toward repetition by finding, by making explicit, by urging, the prior cases. At this point there enters into the picture an ethical element, the argument that courts and other officials not only do, but should continue what they have been doing. Here again, the first analog is in the folkway, or the individual habit. I do not know why, nor do I know how, but I observe the fact that what one has been doing acquires in due course another flavor, another level of value than mere practice, a flavor on the level of policy, or ethics, or morality. What one has been doing becomes the right thing to do. Not only the expected thing, but the thing whose happening will be welcomed, and whose failure to happen will be resented. This is true in individuals whose habits are interrupted. This is true in social intercourse when the expected event, when the expectation based upon the knowledge of other people's habits, materializes or fails to materialize. Indeed, in social matters in the large, there develops distinct group pressure to force conformity with the existing and expected social ways. All of this now, the lawyer brings to bear upon law itself. Here speaks the judicial conscience. And apart from the unreasoned and unreasoning fact that oughtness attaches to practice, they are, particularly in the case of officials, and most particularly in the case of judges, reasons of policy to buttress this ethical element. To continue past practices is to provide a new official in his inexperience with the accumulated experience of his predecessors. If he is ignorant, he can learn from them and profit by the knowledge of those who have gone before him. If he is idle, he can have their action brought to his attention and profit by their industry. If he is foolish, he can profit by their wisdom. If he is biased, or corrupt the existence of past practices to compare his action with, gives a public check upon his biases and his corruption, limits the frame in which he can indulge them unchallenged. Finally, even though his predecessors may themselves, as they set up the practice, have been idle, ignorant, foolish, and biased, yet the knowledge that he will continue what they have done gives a basis from which men may predict the action of the courts, a basis to which they can adjust their expectations and their affairs in advance. To know the law is helpful, even when the law is bad. Hence, it is readily understandable that in our system there has grown up first the habit of following precedent, and then the legal norm that precedent is to be followed. The main form that this principle takes we have seen. It is essentially the canon that each case must be decided as one instance under a general rule. This much is common to almost all systems of law. The other canons are to be regarded rather as subsidiary canons that have been built to facilitate working with and reasoning from our past decisions. But it will have occurred to you that despite all that I have said in favor of precedent, there are objections. It may be the ignorance or folly or idleness or bias of the predecessor which chains a new strong judge. It may be, too, that conditions have changed, and that the precedent, good when it was made, has since become outworn. The rule laid down the first time that a case came up may have been badly phrased, may have failed to foresee the types of dispute which later came to plague the court. Our society is changing, and law, if it is to fit society, must also change. Our society is stable, else it would not be a society, and law which is to fit it must stay fixed. Both truths are true at once. Perhaps some reconciliation lies along this line, that the stability is needed most greatly in large things, that the change is needed most in matters of detail. At any rate, it now becomes our task to inquire into how the system of precedent which we actually have works out in fact, accomplishing at once stability and change. We turn first to what I may call the orthodox doctrine of precedent, with which, in its essence, you are already familiar. Every case lays down a rule, the rule of the case. The express ratio decidendi is prima facie the rule of the case, since it is the ground upon which the court chose to rest its decision. But a later court can re-examine the case, and can invoke the canon that no judge has power to decide what is not before him, can, through examination of the facts or of the procedural issue, narrow the picture of what was actually before the court, and can hold that the ruling made requires to be understood as thus restricted. In the extreme form, this results in what is known as expressly confining the case to its particular facts. This rule holds only of red-headed Walpoles and pale magenta Buick cars. And when you find this said of a past case, you know that in effect it has been overruled. Only a convention, a somewhat absurd convention, prevents flat overruling in such instances. It seems to be felt as definitely improper to state that the court in a prior case was wrong, peculiarly so if that case was in the same court which is speaking now. It seems to be felt that this would undermine the dogma of the infallibility of courts. So lip service is done to that dogma, while the rule which the prior court laid down is disemboweled. The execution proceeds with due respect, with mandarin courtesy. Now this orthodox view of the authority of precedent, which I shall call the strict view, is but one of two views which seem to me wholly contradictory to each other. It is in practice the dogma which is applied to unwelcome precedents. It is the recognized, legitimate, honorable technique for whittling precedents away, for making the lawyer, in his argument, and the court, in its decision, free of them. It is a surgeon's knife. It is orthodox, I think, because it has been more discussed than is the other. Consider the situation. It is not easy thus to carve a case to pieces. It takes thought, it takes conscious thought, it takes analysis. There is no great art and no great difficulty in merely looking at a case, reading its language, and then applying some sentence which is there expressly stated. But there is difficulty in going underneath what is said, in making a keen re-examination of the case that stood before the court, in showing that the language used was quite beside the point, as the point is revealed under the lens of leisured microscopic refinement. Hence the technique of distinguishing cases has given rise to the closest of scrutiny. The technique of arguing for a distinction has become systematized. And when men start talking of authority, or of the doctrine of precedent, they turn naturally to that part of their minds which has been consciously devoted to the problem. They call up the cases, the analyses, the arguments, which have been made under such conditions. They put this together and call this the doctrine. I suspect there is still another reason for the orthodoxy. That is that only finer minds, minds with sharp mental scalpels, can do this work, and that it is the finer minds, the minds with sharp cutting edge, which write about it, and which thus set up the tradition of the books. To them it must seem that what blunt minds can do as well as they is poor, but that which they alone can do is good. They hit in this on a truth in part. You can pass with ease from this strict doctrine of precedent to the other. If you can handle this, then you can handle both, not vice versa. The strict doctrine, then, is the technique to be learned, but not to be mistaken for the whole. For when you turn to the actual operations of the courts, or indeed to the arguments of lawyers, you will find a totally different view of precedent at work beside this first one, that I shall call, to give it a name, the loose view of precedent. That is the view that a court has decided, and decided authoritatively, any points or all points on which it chose to rest a case, or on which it chose, after due argument, to pass, no matter how broad the statement, no matter how unnecessary on the facts or the procedural issues. If that was the rule the court laid down, then that the court has held. Indeed, this view carries over often into dicta, and even into dicta, which are grandly obiter. In its extreme form, this results in thinking and arguing exclusively from language that is found in past opinions, and in citing and working with that language wholly, without reference to the facts of the case which called the language forth. Now it is obvious that this is a device not for cutting past opinions away from judges' feet, but for using them as a springboard when they are found convenient. This is a device for capitalizing welcome precedents, and both the lawyers and the judges use it so. And judged by the practice of the most respected courts, as of the courts of ordinary stature, this doctrine of precedent is like the other, recognized, legitimate, honorable. What I wish to sink deep into your minds about the doctrine of precedent, therefore, is that it is two-headed. It is Janus-faced. That it is not one doctrine, nor one line of doctrine, but two, and two which, applied at the same time to the same precedent, are contradictory of each other. That there is one doctrine for getting rid of precedents deemed troublesome and one doctrine for making use of precedents that seem helpful. That these two doctrines exist side by side. That the same lawyer in the same brief, the same judge in the same opinion, may be using the one doctrine, the technically strict one, to cut down half the older cases that he deals with, and using the other doctrine, the loose one, for building with the other half. Until you realize this, you do not see how it is possible for law to change and to develop, and yet to stand on the past. You do not see how it is possible to avoid the past mistakes of courts, and yet to make use of every happy insight for which a judge in writing may have found expression. Indeed, it seems to me that here we may have part of the answer to the problem, as to whether precedent is not as bad as good supporting a weak judge with the labors of strong predecessors, but binding a strong judge by the errors of the weak. For look again at this matter of the difficulty of the doctrine. The strict view that cuts the past away is hard to use. An ignorant, an unskillful judge will find it hard to use. The past will bind him. But the skillful judge, he whom we would make free, is thus made free. He has the knife in hand, and he can free himself. Nor, until you see this double aspect of the doctrine in action, do you appreciate how little in detail you can predict out of the rules alone. How much you must turn, for purposes of prediction, to the reactions of the judges to the facts, and to the life around them. Think again in this connection of an English court, all the judges unanimous upon the conclusion, all the judges in disagreement as to what rule the outcome should be rested on. Applying this two-faced doctrine of precedent to your work in a case class, you get, it seems to me, some such result as this. You read each case from the angle of its maximum value as a precedent, at least from the angle of its maximum value as a precedent of the first water. You will recall that I recommended taking down the ratio decidendi in substantially the court's own words. You see now what I had in mind. Contrariwise, you will also read each case for its minimum value as a precedent, to set against the maximum. In doing this, you have your eyes out for the narrow issue in the case, the narrower the better. The first question is, how much can this case fairly be made to stand for by a later court to whom the precedent is welcome? You may well add, though this will be slightly flawed authority, the dicta which appear to have been well considered. The second question is, how much is there in this case that cannot be got around, even by a later court that wishes to avoid it? You have now the tools for arguing from that case, as counsel on either side of a new case. You turn them to the problem of prediction. Which view will this same court, on a later case on slightly different facts, take? Will it choose the narrow or the loose? Which use will be made of this case by one of the other courts whose opinions are before you? Here you will call to your aid the matter of attitude that I have been discussing. Here you will use all that you know of individual judges, or of the trends in specific courts, or indeed of the trend in the line of business, or in the situation, or in the times at large, in anything which you may expect to become apparent and important to the court in later cases. But always and always, you will bear in mind that each precedent has not one value, but two, and that the two are wide apart, and that whichever value a later court assigns to it, such assignment will be respectable, traditionally sound, dogmatically correct. Above all, As you turn this information to your own training, you will, I hope, come to see that in most doubtful cases, the precedents must speak ambiguously until the court has made up its mind whether each one of them is welcome or unwelcome. And that the job of persuasion which falls upon you will call, therefore, not only for providing a technical ladder to reach on authority the result that you contend for, but even more, if you are to have your use of the precedents made as you propose it, the job calls for you on the facts to persuade the court your case is sound. People. And they are curiously many who think that precedent produces or ever did produce a certainty that did not involve matters of judgment and of persuasion, or who think that what I have described involves improper equivocation by the courts or departure from the court ways of some golden age. Such people simply do not know our system of precedent in which they live.